Committee will come to order. Boy, it feels great being back home, doesn't it, Louise? It feels good to be back home here at the Rules Committee. Well, no, and that's exactly right. And I will tell you that
Turn on my microphone.
well, you look great.
Well, I feel great. Did a lot of good work, got a lot of exercise walking around the district. And
Jim McGovern's smiling.
Jim, he always is.
He is?
It's a new
He is.
prescription.
Oh, is that it?
We haven't seen Jared for quite a while, but we think he might drop in. I want to see him in a little while.
Yeah, well,
He's got some suspensions on the floor.
yeah, well, I sensed that this was a good month for the staff and gave them a chance to get time off.
You know what my staff did for me?
Well, tell me.
When I got here today, they had this beautiful cake engraved on the top, just because, and an orchid and a bouquet of flowers. Now, this was the rules staff.
Oh, yes.
I
the ones
can't
that
wait.
love you the
I
most.
hope that my staff over in the Rayburn building is hearing that, because I'd hate to. I don't want to have to go tell them in person that they didn't do right by me.
Mr. Chairman,
You know what my staff asked me?
What?
When am I leaving? Yes, sir.
can I go get the plates and cake's going to be served
Best
today?
cake
Is that my
I've
understanding?
ate in my life.
They ate that
Oh,
cake.
From
That cake is-
Heidelberg Pastries. Have you heard about that?
No, I haven't
Over
get
in
that out.
Virginia somewhere. Try it. You have, right?
Oh, well, I didn't get rhubarb pie. I didn't get cake. You know, I think it's the thing about
But since
Gordon.
Bob died and we don't drive down anymore, and it's hard for me to carry 5 pies, but I'm going to see if I can get them shipped. Okay.
Well, I'm glad we're back. Yes, my staff was very nice to me. They even talked to me today.
They did.
Yeah, they even talked to me.
But not tomorrow.
Well, I had no telling.
Okay.
You know, let
Okay.
good things happen.
Yeah.
Well, good afternoon and welcome back. I hope everybody had a restful and productive August break. I went to Philmont Scout Ranch for my 15th visit. Louise, every summer I try and go and teach a course to adult leaders. It's called Coaching and Mentoring.
Mm-hmm.
And it's really one of the highlights where I get to drive for 6 hours all by myself and then get in the mountains and then drive back for 6 or 7 hours. I had a great time.
Good.
And you had time at an
The
opportunity.
summer nutrition program.
Summer nutrition
Best time I ever had.
Yeah, well, those are good times for
Those
us.
kids were just wonderful.
Yeah, and seeing the kids is great. Today, the Rules Committee will consider H.R. 2357, the Accelerating Access to Capital Act of 2015, H.R. 5424, the Investment Advisors Modernization Act of 2016, and H.R. 5063, the Stop Settlement Slush Funds Act of 2016. H.R. 2357, the Accelerating Access to Capital Access of 2015, is a legislative package from the House Financial Services Committee that eliminates unnecessary costs that impede the growth of small business. The package simplifies disclosures, lowers compliance costs, and allows eligible companies to direct more resources to growing their business rather than working on red tape. Specifically, Title II of the Act will allow small business to access the necessary capital to grow despite the costly burdens of federal securities registration. Small businesses are the primary innovators and job creators of our economy, but the cost of regulations falls heaviest on them. And of course, I know that many of us support protecting investors and maintaining orderly and efficient markets, but excessive and simply unnecessary regulations and overburden small businesses and companies to the detriment of consumers and really job growth and job creation. H.R. 5424, the Investment Advisors Modernization Act of 2016, amends the Investment Advisors Act of 1940. I can't see today. 1940, and directs the Securities and Exchange Commission to amend its rules to modernize certain requirements related to investment advisors to help secure robust capital formation at a time that burdensome regulations are making access to capital all the more difficult. H.R. 5424 in no way diminishes the SEC's existing authorities under the IAA and other federal security laws to prosecute advisors who engage in security frauds or who look at improper conduct. The Rules Committee today will also consider H.R. 5063, the Stop Settlement Slush Funds Act of 2016, a most important piece of legislation and one which I believe will draw a lot of interest. This is legislation that prohibits terms in the Department of Justice settlements that direct or provide for payments to non-victim third parties. A year-long committee investigation has revealed that the DOJ is pushing and even requiring settling defendants to donate money to non-victim third parties. Its documents have discovered and shown that groups that stood to gain from these mandatory donations lobbied the Department of Justice to include them in settlements that the DOJ itself conceived through mandatory donation provisions. The executive director of the Hawaii Legal Aid Foundation went so far as to praise then Associate Attorney General Tony West, and I state, I would be willing to build a statue of West, and then we could bow down to the statue every day after we got more than $200,000. End of quote. I applaud Chairman Goodlatte for bringing forward this legislation. National spending decisions should only be made by a Congress, and accountable to that is what the United States Congress should be. Unelected bureaucrats in the executive branch who are simply funding pet projects with no oversight or no consequences. I believe this money should go back to the Treasury, and that is why we're here today to discuss this issue. I want to welcome, as we always do, we have great members from super committees. In this case, we have Congressman Rob Hurt from Virginia on the first panel. Perhaps he'll stick around. And Ranking Member Financial Services Committee, Congresswoman Maxine Waters. I want to thank you both for being here. Without objection, anything you have in writing will be entered into the record. And I'd like to yield now to the gentlewoman from New York, the Ranking Member of the committee, Mrs. Slaughter.
I'll wait for the testimony. Thank you very much.
Thank you very much. Well, welcome back, everybody. Rob, we're delighted that you're here. These are several bills that you have not only authored some yourself, but understand them. We're delighted that you're here, and the gentleman is now recognized.
Thank you, Mr. Chairman. Mr. Chairman, Ranking Member, we appreciate the opportunity to testify today on H.R. 2357, the Accelerating Access to Capital Act. Today, we're going to discuss several pieces of legislation which have been incorporated into H.R. 2357, the Accelerating Access to Capital Act, authored by my colleague, Ms. Wagner of Missouri. The measure now includes two additional pieces of legislation, H.R. 4850, the Micro Offering Safe Harbor Act, authored by Mr. Emmer of Minnesota, and H.R. 4852, the Private Placement Improvement Act, authored by Mr. Garrett of New Jersey. The latter bills respectively represent Titles II and Title III within H.R. 2357. Like many of us here, when I first ran for Congress, I ran because I believed that Washington had become too far removed from the people it is supposed to represent. In the wake of the 2008 financial crisis, I was concerned, unfortunately just as I am today, that many of the policies coming out of Washington were negatively impacting 5th District Virginians and dampening the future for our children, our grandchildren, and particularly those policies that hinder economic growth. I represent a sweeping district along the Blue Ridge Mountains. It spreads from Fauquier County south to the North Carolina border. Within our district, there are a few more urban areas with robust economic activity, but most of our district is comprised of rural countryside and Main Street courthouse towns. Unfortunately, much of our district has suffered devastating unemployment in recent years, and after the crisis, at times reaching double-digit unemployment. That is why, when I came to Congress, that I was so pleased to sit on the Financial Services Committee. In my eyes, the work that we do is critical to economic growth and development and has a real impact on helping smaller companies access the capital markets. All of that is essential to helping our small businesses, who are our nation's most dynamic job creators, grow and expand which creates jobs. H.R. 2357 is comprised of three titles, the first being the Accelerating Access to Capital Act, authored by Ms. Wagner. This measure would amend the Securities and Exchange Commission's Form S-3 registration statement to expand eligibility to smaller reporting companies. The cost of securities regulation falls heaviest upon smaller companies, and Title I eliminates the unnecessary costs that impede the growth of small business by expanding the use of Form S-3 to smaller reporting companies that are already current on their SEC reporting requirements and are publicly registered for at least 1 year. This would lower compliance costs and would not eliminate the SEC's ability to bring enforcement actions for fraud, abuse, or market manipulation. Every one of the investor protection provisions in the federal securities laws would remain unchanged, and any company that seeks to use Form S-3 must be current on their required SEC filings. Title II of the legislation is the Micro Offering Safe Harbor Act, authored by Representative Emmer. This measure would amend the Securities Act of 1933 to provide an exemption for small private offerings of securities known as micro offerings. Certain requirements must be met for this exemption to apply, such as requirements that each investor has to have a pre-existing relationship with the owner, there must be 35 or fewer purchasers, and the amount cannot exceed $500,000. Any suggestion that this opens a door to fraud or abuse is misguided. Indeed, the SEC still has the authority to enforce any fraud or abuse alleged, and every investor protection provision in the federal securities laws remains intact. Further, an amendment adopted during the committee's markup prohibits bad actors from availing themselves of this exemption. Title III of this bill, the Private Placement Improvement Act, authored by Representative Garrett, would direct the SEC to revise Regulation D to eliminate the SEC's harmful proposed rule that is hindering small businesses' ability to raise capital. Title II of the Bipartisan Jobs Act made it easier for startups to market their securities, but when the SEC implemented that provision, the SEC at the same time proposed a separate rule that would impose new regulatory requirements on small companies seeking to use Rule 506 to raise capital. This is clearly inconsistent with Congress's intent to make it easier for startups and smaller companies to raise capital. Now these companies seeking to raise capital using Rule 506's safe harbor would be required to submit additional Form D filings, raising the total number of Form D filings from 1 to 3, and are required to do so on an ongoing basis. The SEC has not acted on this proposed rule, which is why this measure is so important. When the SEC or any agency does not follow Congress's intent, it's incumbent upon Congress to act, which is precisely the purpose of Title III of this legislation. The package before your committee today is about ensuring that our nation's small businesses and smaller public companies are in the best position possible to do what they do best, to innovate, grow their businesses, and create jobs. It is important to remember that the SEC has a three-pronged mission: to protect investors, to maintain fair, orderly, and efficient markets, and to facilitate capital formation. Unfortunately, to the detriment of U.S. capital markets, the SEC often neglects its capital formation responsibilities. Every one of these measures is aimed at enhancing capital formation in the name of economic growth and job creation. Moreover, none of the titles within this legislation would weaken the SEC's enforcement abilities, nor would they undermine investor protection. Rather, they strike the appropriate balance, I would submit, in the SEC's three-part mission in the name of capital formation, economic growth, and investor protection. I thank the chairman and the ranking member for their time, and I'm happy to answer any questions.
Thank you very much, Ms. Waters. Welcome. Good to see you.
Chair, Mr.
Maxine,
Chairman.
did you have a chance to hear that yesterday was Alcie's birthday? Is that right? Alcie?
No, I did not.
Alcie Hastings, and I won't say how old, he kind of said it in silence up here, but Alcie Hastings had a birthday yesterday.
Happy birthday, Mr. Hastings. You're so welcome.
We'll second that.
All right, Mr. Chairman, and Ranking Member Slaughter, and members of the committee, I thank you for allowing me to share my views on H.R. 2357 and H.R. 5424. These bills include harmful regulatory setbacks or rollbacks that would put investors and our capital markets at risk. I have to tell you, Mr. Chairman and members, I am a little bit dismayed about where I'm starting off today coming back after this break that we've had. Unfortunately, I went to Louisiana to witness the devastation and the harm that has been caused up in Baton Rouge. And I'm anxious to get on with taking a look at what this Congress can do as we deal with the upcoming reauthorization of the flood insurance bill, the national flood insurance legislation that we are going to have to be involved with. We have so many issues, including mapping. Many of the people in Baton Rouge didn't have insurance and didn't know they were supposed to have insurance. They're not covered. And so FEMA and SBA and our other agencies that are involved with support for these areas following this kind of devastation are tasked with the responsibility of helping these people to try and get into homes and to try and get their lives back together. So I'm not pleased that I have to be here today on these issues where we're talking about protection for, some of the most profitable industries in this country, rather than focusing on what is happening and what is going to continue to happen as we experience the global warming that is taking place. So here we are, and we're not dealing with flood. The first order of business is to try and, for some reason, protect these private equity firms and not the survivors of Baton Rouge, for example. So there are thousands of residents who are still without homes and businesses that are struggling to recover instead of addressing the needs of the people. I met with General Honoré while I was down there, and he has a good take on what we need to be doing to help small businesses recover and get back up and going and getting rid of some of the bureaucracy, et cetera. And I've invited him to come and meet with, on a round table on both sides of the aisle, our staffs, to talk about how we can do that. And that's where I'd rather be putting my attention right now. However, here we are. H.R. 2357 is a package of 3 bills that would expose our financial markets to the type of fraudulent activity that the Securities and Exchange Commission and Congress have worked so hard to curtail. First, it would allow small companies to publicly offer their stock as an accelerated filer without first alerting the FEC or gaining its approval. Currently, this accelerated filer status is reserved for larger companies that meet the standards of and are traded on a national stock exchange. They are also closely followed by analysts, giving investors more insight into their activities. Companies traded off exchange simply don't have the same safeguards in place. Second, it would recreate a private securities offering that the SEC eliminated in 1999 after concluding that, in fact, that it did, in fact, facilitate fraud. The bill would carve out a scenario where a private company could sell stock to certain investors with a pre-existing relationship with the company without providing them or the SEC with any information. This stock could then be distributed to the public at large without restriction, and again, without any information. The result would be to destroy the carefully crafted crowdfunding and Regulation A exemptions in the Jobs Act and encourage fraud. And as you know, both sides of the aisle came together around the Jobs Act, and we've worked very hard in a bipartisan way to make sure that we had legislation that could help and provide additional resources for small businesses and entrepreneurs who really didn't have access to credit, but they could use this act for startups and for expansion. And so we need to be mindful of that. Lastly, the bill would halt the SEC's efforts to implement important investor protections in the private securities market. It would block the commission from requiring companies to file a short, simple notice of a sale and from preventing private equity and hedge funds from using misleading advertising materials. These changes in our securities laws would leave investors and regulators in the dark about investments in a market that is already rife with fraud. I urge my colleagues to join me, investor advocates, and the state securities regulators in opposing H.R. 2357. I'm also strongly opposed to H.R. 5424, a bill that would put investors, retirees, and consumers at risk by undermining the significant oversight and transparency measures Congress imposed on the shadow banking industry under the Dodd-Frank Act. For example, the bill would make it harder for the SEC and the Financial Stability Oversight Council to oversee private fund advisors and protect our financial markets from bad actors and systemic risk. It would remove basic investor disclosures, such as client notification of advisors' ownership changes, that those addressing conflicts of interest on proxy votes. And it would create a loophole by exempting certain private funds from annual audit requirements. When it comes to private equity funds and hedge funds, it is clear that more regulation is needed, not less. In the past 3 years, the SEC has brought a dozen enforcement actions against private equity advisors that have violated securities laws at the expense of investors. And according to the New York Times, profit-driven private equity firms are increasingly investing in emergency services companies and the mortgage market, which has led to slower reaction times for emergency services, aggressive mortgage collection practices, and the same sort of foreclosures abuses that we witnessed before the financial crisis. What's more, the one quarter of the investments in private equity funds come from public pensions. That means our teachers, police officers, and firefighters could lose out on their hard-earned retirement savings if unscrupulous advisors take advantage of the lax oversight and loopholes in this bill. This bill is opposed by a broad range of groups representing consumer and investor advocates, state securities regulators, institutional investors, and labor unions representing workers who may be invested with private equity firms through their pensions or who may have been inappropriately laid off following private equity takeovers of their employers. So while I appreciate the efforts to limit some aspects of this bill, the overall impact of the legislation would still be detrimental to investors. I therefore strongly urge my colleagues to stand up for retirees and other private fund investors and oppose this legislation. So, Mr. Chairman, I thank you again for this consideration today. I come here knowing and understanding that Republicans are in the majority and that this kind of legislation will continue to see its way past the Democrats on the financial services of this Congress and see its way even to the floor, get stopped on the Senate or get stopped by the president. And I feel as if we're wasting our time. We're wasting Republicans' time. We're wasting Democrats' time. And these bills aren't going to go anywhere in the final analysis. And I just wish that we would deal with national flood insurance issues, with homelessness issues, with other issues where we can really impact the lives of so many people in this country who are, beginning to understand this kind of deadlock and who are unhappy with all of us. And so while I come here today, I'm not hopeful that I'll be able to prevail. And I just wish that I didn't have to keep using my time this way and that I could work on some real issues to deal with the real problems of this nation. I thank you, Mr. Chairman.
I don't presume to be a meteorologist, nor have I spent a huge amount of time on the Louisiana circumstance, but it's my understanding that it was not a floodplain. It was 21 inches of rain in one area that really caused this. And I do understand what you were talking about. Nobody had flood insurance because they weren't in a floodplain. But, you know, even in Texas, a year ago in May, we got 2 trillion gallons of water that fell on Texas. And it was an amazing sight. But you're right, where you had nothing, you could all of a sudden get a lot of water, and we're learning how to live with that. But we do pray for and hope that the people of Baton Rouge and all the help that's come that way, and I know a lot of people from Dallas, Texas have headed that way, and people all over the country, and they do need help. And I hope we do stay on that issue very much so, all of our committees. And thank you very much
Thank
for
you.
being here today. Mrs. Fox?
Thank you very much, Mr. Chairman. I appreciate both of our colleagues being here and presenting these bills. I think they are good bills, and I think they're long past due our correcting the abuses of the Justice Department in this area, in particular with the bill on the slush funds. But I appreciate Mr. Hertz bringing the other bills also and bringing them to our attention. And I hope this is not his last visit to the Rules Committee. I'm going to miss him a lot. He's been a shining light here in the Congress, and very sorry to see him leave us in such force after having been here such a short time. I have no questions. I thank you very much, and I'm glad to see Mrs. Waters too here after the break, and I thank you for your going down to Baton Rouge. Thank you very much, Mr. Chairman.
Yes, ma'am. Ms. Slaughter?
Thank you, Mr. Chairman, and thank you both for being here. Ranking Member Waters, I have a couple of questions that I'd like to ask you. These regulations were put in place by the SEC. Is that correct?
Yes,
Because of fraud,
that's right.
because of problems going on. As I understand it, studies have found that 80% of the stock manipulation cases involve non-exchange traded stocks, like we're talking about here, that will set them free entirely from SEC oversight. Is that correct?
That's correct.
So what we're doing is really just kind of an anything goes
That's
bill. Studies show the positive correlation, I think, between stock manipulation and relaxed disclosure requirements, which is certainly obvious. We would never ponder that one very long. Why would we want to roll back the protections that we have against manipulation and fraud? What purpose would anybody have in putting forth a bill like that?
Well, I don't know, but the SEC has been very clear, and
I'm
know,
assuming they oppose this bill.
absolutely oppose this bill.
I understand Mr. Hinojosa offered an amendment just to keep some of the modest investor protections in place, but was turned down. So it's whole hog or none here, as we say in Kentucky, right?
That's right.
They wanted to relieve any burden on people who simply sell stock to anybody on short notice. Well, I know what you're saying, that you don't feel like you've got much of a chance up here, but for whatever it's worth, you got my vote.
Thank you.
I yield back.
Gentlewoman, would you yield back time? The gentleman from Oklahoma, Chairman Cole.
I have no questions, although, again, these are two great members. It's always good to have both of them here. I want to share Ms. Fox's sentiment about my good friend from Virginia, who may be making his last appearance, but has been just a terrific member. Just a credit, honestly, to your district, to your state, and certainly our conference. And Robert, I've really appreciated working with you. I really have. Not to mention, I can generally find him occasionally smoking a cigar on the house patio. So he has many qualities that I value and will miss greatly. That amongst them. But most of all, just miss you as a legislator and a friend. You've been a great member, and hope this isn't your final turn at public service. You were a fine state legislator. You've been a fine member of this institution. You've got a great future if this is something that you want to pursue another way, another time. So just thank you for your service. Maxine, just thank you for being here, because you always grace us when you come. It's always worth listening. So thank you very much. Yield back, Mr. Chairman.
Thank you very much. The gentleman speaks very kindly and clearly. I intend at the end to talk about going to Danville, Virginia for gentleman a couple years ago, and I've never had, no matter all the places I've been across the country, did I have more people come up and say great things about the person that they were supporting. You remember that too, probably. Yes, sir. Mr. McGovern. Judge Hastings, Mr. Birthday Boy. You know, being a birthday guy at age 80 is awesome, Judge. I hope I make it. Yeah, I hope I make it. You know, I got to 60 and now it's kind of like, got to stay after it. You make it look too easy. Oh, is it after 80? Okay, all right. I'm counting on that. Rob?
Mr. Chairman, if I could get my September started on the right
Gentleman's
note.
recognized.
Thank you, Mr. Chairman. I wanted to answer Ms. Waters' question about why are we here. I heard all through August why are folks working on things that aren't going to go anywhere and aren't going to get done, and I heard the low opinion that folks have of this institution. And then I sit and I look at the colleague that I was elected with 5 years ago, Mr. Hurt, and he could have just said, you know what, I'm leaving, and so I'm done. He could have said, you know what, the check's already been cashed, and nothing's going to get done anyway, so I'm just going to quit. But here we are. We've got 30 days left in perhaps in his congressional career, and he's still trying to push things through the tape. And he's not doing it because he's going to get some sort of red meat Republican press release out of it. He went to the other side of the aisle, and when he introduced his bill, he found a Republican and he found 2 Democrats. So it was a perfectly bipartisan bill. He kept selling it, so he found another Republican, another Democrat. And as I look at the ways success begets success, I'm going to miss Mr. Hurt, because I think his leadership style is one of those styles that we need here to bring people together. I would like to think that I'm a people bringer together, and I know that my friend from my friend Ms. Waters is a bringer together of folks. We may not be as good at it as Mr. Hurt is, but if we keep asking the question, why does nothing ever get done, I suppose the answer will always be that nothing will get done. I hope that you're going to see the same bright light that I see, because the bright light's sitting right beside you here on the dais. So we can. It doesn't have to be the big things. It can be the little things today and medium-sized things tomorrow, and we get to the big things down the road. Mr. Hurt and I have never seen a successful appropriations process move through the Senate in our time here, move to the president's desk in our time here. And if we had more folks who wouldn't take no for an answer and who wouldn't quit until the final bell rang, I think we would all not just get more done, but we'd feel better about ourselves, and our constituents would feel better about us too. And I thank you both for participating in making that a reality. Mr. Chairman, I yield back.
Thank you very much. The gentleman from Georgia, Mr. Collins, does not say time. The gentleman from Alabama. The gentleman from Washington. Okay, good, it is, and you look great also. Did Carol get her money's worth out of you? Okay. In some defense of the gentleman, I'd like to just for the record note that the gentleman worked on H.R. 5424, the Investment Advisors Act of 1940, on a bipartisan basis, that several other people signed on the bill with you. And Mr. Hurt, I want to say that I have always known you as a gentleman who did not try and jump out into the diving board by yourself. You got a whole bunch of people with you. You've worked on things with people. You've never tried to make it a make it or break it circumstance, and you tried to do things based upon a consensus. And I would say to you that I think what you did today in the Rules Committee is the embodiment of not only what people think about you, but what I do too, and that is you brought a bill up, even if people oppose it, where a whole bunch of people, perhaps on the other side of the aisle, did work with you. And I think that's a lot of what this, being a member of Congress, is about. I think it's probably more like the Venn diagram, where you try and find the things that you have in common, even if some blocks of interest are not together, you found the common interest. And Rob, I want you to know you've done well, you've served your people well, and I'm very proud of you, and congratulations. I want to thank each of you for being here today, and if the committee has no further questions, thank you very much. The committee would now move to the discussion that we will have on H.R. 5063, and the gentleman from Virginia, who is the chairman of the Judiciary Committee, and the gentleman, Mr. Johnson from Georgia, will please come forth. And I don't know, I show here that the gentlewoman, Sheila Jackson Lee, may be there at some point, and I know that we've got at least 2 other members that would wish to give testimony later. Mr. Chairman, we're delighted that you're back. We've already talked about some of the substance of your bill, 5063, the Stop Settlement Slush Funds Act of 2016, but that's what the gentleman's here for, and the gentleman would note that in my opening statement, without objection, anything either of you have in writing will be entered in the record, and the young chairman's now recognized.
Well, thank you, Mr. Chairman. I appreciate the opportunity to testify. In brief, the Department of Justice is systematically subverting Congress's spending power by requiring settling parties to donate money to activist groups. H.R. 5063 stops that. The Stop Settlement Slush Funds Act of 2016 is a bipartisan bill that I introduced on April 26. It's the culmination of a 2-year investigation by the House Judiciary and Financial Services Committee. During that period, the committee made multiple records requests to DOJ and non-governmental entities, interviewed witnesses, and held 2 oversight hearings. This was followed by a legislative hearing on the bill on April 28, 2016, within the Regulatory Reform, Commercial and Antitrust Law Subcommittee. And on May 11, the committee ordered H.R. 5063 favorably reported in a bipartisan vote of 16-8. Mr. Chairman, in just the last 2 years, DOJ has directed nearly $1 billion to activist groups entirely outside of Congress's spending and oversight authority. Of that, over $500 million has already been dispersed or is committed to being dispersed. In some cases, these mandatory donation provisions reinstate funding Congress specifically cut. And rather than stop its activity once the Judiciary and Financial Services Committees began investigating it, DOJ has doubled down. As recently as April of this year, another major DOJ bank settlement required $240 million in financing and/or donations. Serious people on both sides of the aisle understand that Congress must reassert itself. A major theme of the Speaker's A Better Way initiative is that the spending power is one of Congress's most effective tools in reining in executive overreach. Liberal legal scholar Abner Mikva agrees. To ensure that Congress would act as the first branch of government, the constitutional framers gave the legislature virtually exclusive power to control the nation's purse strings. They knew that the power of the purse was the most far-reaching and effectual of all governmental powers. The Stop Settlement Slush Funds Act of 2016 reasserts Congress's spending power by prohibiting settlement terms that direct payments to non-victim third parties. Payments to provide restitution for or otherwise directly remedy actual harm directly caused are not affected. Neither are payments for services rendered in connection with the case, such as for settlement monitors or audits. Opponents' central argument is that DOJ needs flexibility to go beyond victims and address generalized harm in environmental and other cases. On the contrary, the DOJ's authority to settle cases requires the ability to obtain redress for actual victims. However, once direct victims have been compensated, deciding what to do with additional funds extracted from defendants becomes a policy question properly decided by elected representatives in Congress, not agency bureaucrats or prosecutors. For example, the legislation explicitly permits payments to remediate environmental damage. However, if direct remediation of the harm is impossible or impractical, the full penalty is paid, but into the Treasury for elected representatives to decide how best to spend it. Violators are never let off the hook. Do not be fooled by opponents' scare tactics. They claim that the legislation could prohibit remedies used in settlements covering workplace discrimination, harassment, and consumer privacy. The bill does not preclude such remedies. Nothing bars DOJ from requiring a defendant to implement workplace training and monitoring programs. The ban on third-party payments merely ensures that the defendant remains responsible for performing these remedies itself and is not forced to outsource the work to third parties who might be friendly with a given administration. To summarize, this bipartisan legislation is a critical opportunity to marry oversight with action and to restore Congress's spending power, which is key to reining in executive overreach. And I request the Rules Committee grant an appropriate rule that allows for expeditious consideration of H.R. 5063.
Mr. Chairman, thank you very much. Ms. Johnson, welcome to the Rules Committee. We're glad you're with us. Gentleman's recognized.
Thank you. It's good
Yes,
to
sir.
be back, Mr. Chairman. H.R. 5063, the Stop Settlement Slush Funds Act of 2016, would remove an important civil enforcement tool available to agencies to hold corporations accountable for the general harm caused by unlawful conduct. H.R. 5063 would have potentially disastrous unintended consequences on the remediation of generalized harms in civil enforcement actions. For unlawful conduct with systemic harm, such as an environmental catastrophe, settlements provide a mechanism to provide for the remediation of generalized harms through offsets and other indirect remedies. Similarly, parties seeking to regain public trust may also wish to include voluntary auditing requirements in settlement agreements that ensure that similar violations do not occur in the future. Joel Mintz, an expert in environmental law and enforcement, observes that these settlements can create winners and can create win-win scenarios for all parties involved, including regulators, regulated companies, and local communities, by creating a flexible regulatory climate and repairing, quote, corporate public images that would otherwise be further harmed by negative environmental publicity, end quote. For example, in 2012, Mitsui Oil Exploration Company settled its liability for violations of the Clean Water Act resulting from the Deepwater Horizon oil spill. In addition to civil penalties, Mitsui Oil agreed to facilitate land projects in several states, including Texas, Mississippi, Alabama, Louisiana, and Florida, to conserve critical habitat within the Gulf of Mexico. In this case, and others like it, donations under settlement agreements serve as a critical tool to remedy a general harm and provide the settling party with opportunity to re-earn the public's trust. H.R. 5063 would eliminate these donations in both existing and future settlement agreements. This is true even in cases where the settling party seeks a donation to offset its unlawful conduct or where a party's harmful conduct could not otherwise be remedied. I'm also concerned that this legislation is an unwarranted encroachment on the prosecutorial discretion of civil enforcement agencies. The exercise of enforcement discretion is a traditional power of executive branch agencies. This authority provides broad prosecutorial flexibility to civil enforcement agencies when crafting settlement agreements within the scope of their statutory authority. It is little surprise that the Supreme Court has consistently held that the exercise of such discretion is a core function of the executive's power under the Take Care Clause, as it did in Heckler versus Cheney, where the court observed that the characteristics of a decision of a prosecutor in the executive branch have long been regarded as the special province of the executive branch, inasmuch as it is the executive who is charged by the Constitution to take care that the laws be faithfully executed. Under this constitutional norm, agencies' prosecutorial discretion to settle potential civil actions extends to requiring donations in settlement agreements. Additionally, settlement agreements may exceed the remedies identified in an agency's underlying statute so long as they relate to the agency's statutorily authorized prosecutorial objectives, which generally requires that donations have a sufficient nexus between the underlying violation and the proposed remedy. H.R. 5063 represents a severe departure from this tradition, raising separation of powers concerns and threatening to curtail agency discretion in the enforcement of the law. So in short, when an executive agency sues a private actor and that private actor in a courtroom or in a court proceeding then voluntarily agrees to settle the case by way of a consent order that is signed by a judge, that's a process that the legislative branch is not involved in, should not be involved in, and this legislation inserts the legislative branch into that litigation process to the peril of the public interest. And in closing, I urge my colleagues to oppose this legislation and make in order my colleagues' amendments to this bill, which will follow. And with that, I yield back.
Thank you very much, Mr. Goodlatte. Mr. Chairman, do you suggest in this legislation or require that the money would go to the United States Treasury?
Money would go to the United States Treasury for fines and penalties that are not related to remediating the direct harm caused by the action that the defendant in the case may have committed.
Does that direct them in any way to pay down debt or any particular function that it requires that the money be selected to?
No, it would leave it in the General Treasury of the United States, where the United States Congress, as provided for under Article 1 of the Constitution, would make those decisions.
Mr. Johnson, do you believe that special interest has a more special interest to that than the people of the United States of America that would be directed by Treasury?
Yeah, I believe that when there is a lawsuit filed in a court of law and a settlement arrived at voluntarily by the parties, and that settlement agreement provides for disbursements to various entities in the pursuit of justice, then I think that the American people win, regardless of whether or not you want to label the entity that receives the money as a special interest or not. That special interest, for lack of a better term, would be there to render justice pursuant to the litigation that was filed, and that would be in the public interest. And for that reason, I believe that this bill hurts the pursuit of justice in that it would put the funds into the hands of the legislative branch, which would then use the funds to, say, do things like pay down the national debt or perhaps into a nuclear program to buy more weapons, buy more nuclear weapons, anything that the legislative branch would decide, but it would be unrelated to the litigation that was filed, the harm that was done, and the harm that was sought to be remediated by the consent order. So for that reason, I think that the legislation here should be voted down.
Well, I would politely disagree with you. I asked the question, you're entitled to your answer. Mr. Chairman, can you give us a rundown about how much money we've been talking about over the last few years that the Department of Justice has been seeking these voluntary contributions that were referred to?
Well, these payments that are not to the victims of the alleged offense of the party settling the case now exceed $1 billion. It's going on $2 billion. And just recently, the department entered into another settlement with another financial institution in which $240 million more is being directed. And bear in mind that all of these are under the threat of prosecution. If you don't do what we're asking you to do in this settlement, we're going to take you to court and do this and that.
So you would disagree with the word voluntary contribution?
I would say it's certainly made under a good deal of pressure. And you know what? If they've done wrong, they should be under pressure. But the pressure should be to either pay a fine to the United States government that would go into our general treasury, or pay it to the actual direct victims of the offense that they committed that led to them being fined. And we now have instances where the organizations that have benefited from this go directly to the Justice Department and apply for the funds. They, in some instances, suggest, why don't you include in your settlement funding for our organization, which had nothing to do with the harm that was caused in the alleged underlying crime or violation that may have been committed. And secondly, in some instances, they have these funds have been directed to organizations to replace money that the Congress very consciously chose not to fund. So I think this is a very direct assault on the spending power of the Congress, which is, as I noted, a very important part of our separation of powers and our system of checks and balances.
Well, I'm going to agree with you. I'm very proud of what you've done and would tell you that I believe no special interest is entitled to this. If a company wanted to make a voluntary contribution, they could just go do that. But I believe under duress, lots of things happen, and I would never call that voluntary. And I am delighted you've done that. By the way, I believe this is true under a Republican or Democrat presidency or administration with that power. I think the most important interest that we've got is the interest of the American people, and I agree with what you're doing. Thank you very much, and thank you to both of you. The gentleman from Oklahoma, Chairman Cole.
Thank you very much, Mr.
Yes, sir.
Chairman. I want to welcome both of our colleagues here, and I don't have a lot of questions. Frankly, I just want to thank the chairman for bringing the legislation. I think all executives, this is not a partisan statement, strain at the leash, and they all, I've seen Republican presidents do this, I've seen Democratic presidents do it, and frankly, they're using this as a piggy bank that they don't have any authority to do, in my opinion. It's blatantly unconstitutional. If anybody thinks favorites aren't played or people are rewarded or what have you, then I would suggest you need to rethink about what you know about humanity, because we're all made of the same clay, and both sides do it. This puts the money where it belongs, back in the people's purse, where the people's representatives can make judgments about it. And it's a backdoor to executive branch appropriating that needed to be closed a long time ago. I'm very proud of my friend and his committee for the work they've done in bringing this forward. And I suspect it would be pretty unpopular in a Republican administration. I think, again, any executive branch under either party is going to want this kind of authority and demand it. It's amazing how quickly they all change their minds about earmarks once they become presidents as well. I saw certainly President Obama do that, and I suspect had George W. Bush won his election in 1978 and been in the House, his view of earmarks as a legislator would have been considerable. But it's just simply the appropriating process belongs here. It belongs where it's accountable, where it's transparent, and this is money that's in the possession of the government of the United States. It should be expended and appropriated by the representatives who are elected for that purpose. So I just think this is a very important constitutional issue. It's an issue in terms of the appropriate balance of power between the legislative and the executive branch. You've done a real service in bringing this legislation forward. I just want to thank my friend.
Thank you.
Thank you, Mr. Chairman. Louise?
No questions, thank you.
The gentlewoman does not have any questions. The gentleman from Florida does not seek time. Is there any other member of the committee that would seek time? The gentleman from Georgia, Mr. Woodall.
Thank you, Mr. Chairman. I
Yes,
just
sir.
wanted to ask my friend from Georgia, I want to thank the best of folks, too, that no one's using these things for political purposes, but thinking strictly about Article 1 and Article 2, if the administration makes a request to federalize some wetlands in the Louisiana area, and Congress specifically rejects that request, and then the administration, through the DOJ, settles with an oil company and requires as a part of that settlement that funds be donated to a private organization that would then protect those lands, those very same lands, in perpetuity. The gentleman would say that he could imagine in Article 1, Article 2, a conflict there that needs to be protected against, or he would have no qualms about that whatsoever?
I don't see a Article 1 implication in a scenario where a Article 2 entity, the executive branch, one of the agencies thereunder, brings an action in court, Article 3, and the parties agree to settle the dispute, and as a result, monies are spent pursuant to remediating a harm that generated the lawsuit to begin with, I don't see an Article I issue in that. I see an Article II and an Article III balance of power situation that has been dealt with within the context of those two constitutionally enabled entities, the judicial and the executive branch, to do the business of the American people. And that's the way that our Constitution has set it up. There's no handcuffs on the executive branch in terms of what it can enter into a consent order about to remediate a harm. What this legislation does is intrudes within that careful balance. And in my opinion, it is, it's got constitutional implications. It is possibly unconstitutional. That would have to be decided by a court. And it's also impractical. I mean, we're talking about a public harm that is being addressed by the executive branch through the judiciary. And that's a process that has worked. There's nothing wrong with it. It's not broken. What this does is tries to put the legislative branch into a super majority or a super powerful position so that it can override a judicial action. And I think that it's unwise.
And, Mr. Chairman, would you agree with the gentleman from Georgia's analysis that that the Constitution does not prohibit this kind of action by the judiciary, that the Supreme Court has absolutely upheld this kind of action by the judiciary, but because it implicates the power of the purse, that's why this legislation is required to address the concern?
I think the Congress has every reason to look at these cases and say that money is being diverted from the Treasury, because if you have a settlement that orders money directly to somebody who's been harmed, I completely agree under those circumstances. But if there's no harm to the party that's receiving the money, then but for that agreement, that money would go into the Treasury of the United States, and the Congress of the United States would appropriate the funds, and that's what should happen. And we need to be forceful in speaking out about that. Otherwise, our power of the purse, which is one of the limited checks that we have against an overreaching executive branch of the government, will be further diminished.
I thank the chairman. Mr. Chairman, I yield back.
Thank you very much. The gentleman, Mr. Stivers, do you seek time? Gentleman does not seek time. Any other member of the committee? Thank you very much. I want to thank both of you for being here. The instructions that you have given us today are I think, on target, and that is a question that arises about up to $1 billion, perhaps you said more, that this government is seeking and settling, so to speak, differences with people and sending it to outside sources rather than giving it back to the American people. And I agree with you. So I want to thank both of you for this interesting question that arises today. Hope you have a wonderful day back, and we'll see you on the floor. Thank you very much. We now have at least two other special guests who would be wishing to give testimony. The gentleman from Georgia, the chairman of the Budget Committee, Chairman Price. Mr. Price, welcome. And the gentleman from South Carolina, Mr. Rice. Mr. Rice, we're still trying to, I'm going to use the word make heads or tails. We're trying to determine the ramifications of your amendment. So I'd like to normally I would defer to my very dear friend, the gentleman from Georgia first, but I'd like to defer to you because you've created an ongoing discussion that I'm sure a few people would like to listen to, and it helps us get through our work as we ready getting our rule done, so I'm going to let the gentleman from South Carolina go. Please know that without objection, anything either one of you or the young chairman have in writing will be entered the record without objection. The gentleman from South Carolina is now recognized.
Thank you, Mr. Chairman. Let me tell you a little story. We've been working on a number of permits for construction of infrastructure, and I think that everybody in this room would like to see us invest in infrastructure in this country to keep this country competitive. Well, and everybody in this room knows that the permitting process has become an incredible burden to the point that it takes often a decade to get through the permitting process as it is. Well, there's been a troubling trend developing in my state, and I think other states as well, but I'm aware of my state where when the Army Corps or the governmental entities are considering permitting infrastructure, anybody during that process, after the comment period's over, can file a lawsuit for a very small cost, $1,000 or less. And they can hold up and join the permitting process for years with no skin in the game, with no investment. And during that process, here in South Carolina, in recent times, these cases have been settled by not only mitigation for the proposed infrastructure, but also, well, can you contribute a little money to our operating expenses? Can you contribute a little money to this other entity? Similar to what Mr. Goodlatte was talking about. It's a little expansion of Mr. Goodlatte's bill, and that we're not just talking about bad actors who've done something wrong and are being fined. We're talking about groups who are coming in and challenging 404 permits and are requesting payoffs to drop their challenges to the 404 permits. And what my amendment says is that any settlement proceeds out of a 404, in the process of a 404 permit, would be used strictly for mitigation and not for other purposes. I mean, it is a troubling trend, and it creates almost like a ransom or a blackmail situation if you want to move ahead with your permit. I think it has no place in our 404 process. I think it has no place in our permitting process for infrastructure. I think it's one more thing that holds up our construction of infrastructure and makes this country a little less competitive. So that's what my amendment's about.
Good. Thank you very much. I appreciate that. Ms. Jackson-Lee, we're going to have you go ahead and pull up a chair and join us. Thank you very much. We're delighted. We did expect you, we got two gentlemen, one from South Carolina, one from Georgia, that are really fired up about being on this panel. By the way, so that we don't forget, yesterday was Judge Hastings' birthday. So you'll want to remember that. There was a lot of celebration in Florida yesterday, but the good judge. Mr. Chairman, we're delighted that you're here, and the gentleman's recognized.
Thank you, Mr. Chairman, and I appreciate the opportunity to come before the Rules Committee today. I want to also thank the Judiciary Committee and their staff and the chairman, as well as the parliamentarians, for assisting us along with the Rules staff on these two amendments. I bring to you two amendments that are simply an effort to try to provide transparency for the issue that the Judiciary Committee has brought forward. I fully support the underlying bill. The First Amendment would address the legislation by providing greater transparency so that Congress can track where funds paid from settlement agreements by the executive branch are distributed, and to ensure that the federal agencies and the executive branch comply with the requirements of H.R. 5063. This amendment would provide that an annual report to be made by the Inspector General of each federal agency, highlighting those agreements that violate Section 2A of H.R. 5063. Section 2A, as you know, bars settlement agreements except under two conditions: either payments providing restitution for or otherwise directly remedying an actual harm caused by the party making the settlement payment, or payments for services rendered in connection with the case. That's the First Amendment. The Second Amendment, which you have before you, would require the head of each federal agency to provide an electronic annual report to the Congressional Budget Office of settlement agreements that are consistent with the limitations in H.R. 5063. It may or may not surprise you that the Congressional Budget Office actually has some problem getting this kind of information out of the agencies. And so when we have gone to them and asked them for information when we do our budget and other activities that come under our jurisdiction, they say, I'm sorry, we don't necessarily have that information. So this would require that the agency provide that information to ensure transparency on these settlements. The Second Amendment would sunset after 7 years to permit authorizing committees to review whether or not the information being provided has any utility at all. Both of these amendments include language that would ensure that no additional funds are appropriated for these administrative requirements, and I would urge the inclusion of these amendments, and would also state that, again, the Judiciary Committee was extremely helpful in crafting these amendments, and the parliamentarians in making certain that they were germane.
Mr. Chairman, thank you very much. Very well-balanced, thoughtful amendment. I appreciate you taking time to do that. Ms. Jackson-Lee, previously I had assured the two gentlemen before us that anything they brought in writing would be entered in the record, and I'll do the same for you. The gentlewoman is now recognized. If you please make sure, and you just that green light is on, the gentlewoman is recognized.
Thank you very much. Thank you for the chairman's courtesy. I thank you for the Rules Committee courtesy. And again, let me officially on the record wish one of the senior members of this committee a very blessed happy birthday to you. I'm delighted to be here with my colleagues. Let me first of all say that I'm well aware that H.R. 5063 would not apply if the payment is for restitution to affected parties or remedies actual harm. This is, of course, a prohibition involving the U.S. government for requiring the other party to pay directly to a third party. I have two amendments. I think they're listed as amendment number 7 and number 8. And I would urge adoption of my amendment. They make some exemptions. They address the additional case exemption for those instances where funds are directed to states to remediate the generalized harm of unlawful conduct beyond harms to identifiable victims. One clear example is where such exemption involved the Deepwater Horizon agreements directing payments to states as third parties for general remediation of harms. I think ultimately we attempted to make whole many of those victims, some of whom I visited, oyster fishermen, for example. Under current law, the Environmental Protection Agency may include supplemental environmental projects in settlement agreements to offset the harms of unlawful conduct by requiring parties to undertake an environmentally beneficial project or activity that is not required by law, but that a defendant agrees to undertake in part of the settlement of an enforcement. As the law goes on, a number of cases came under this provision. In 2012, the EPA and Justice Department resolved the civil liability of MOEX through a settlement agreement resulting from the Deepwater Horizon, included funds to several Gulf states. So my point is that there are actually public entities that would be impacted by the way the bill is presently configured. And my amendment, if I can briefly summarize, my amendment would eliminate this harmful prohibition by implementing a common sense exemption for these very type of cases that I've just mentioned. And I'll put my whole statement into the record. These are cases where state entities are actually impacted. Amendment number 8 deals with, resolves when the settlement agreements that resolves a civil action or potential civil action in relation to sexual harassment, violence, or discrimination in the workplace. An example that is not directly related to workplace discrimination, sexual harassment per se, but it does involve a state action that could be considered or is considered discrimination. A few months ago, we saw the Justice Department filed a civil rights lawsuit against the state of North Carolina and other parties declaring North Carolina House Bill number 2, restroom restriction, unlawfully discriminatory. Attorney General Loretta Lynch stated that this complaint was about a great deal more than just bathrooms. She explained, this is about the dignity and respect we accord our fellow citizens and the laws that we as a people and as a country have enacted to protect them, indeed to protect all of us. It is generally an issue of discrimination. And it's about the founding ideals that have led this country haltingly but inexorably in the direction of fairness, inclusion, and equality for all Americans. I'm concerned that as presently construed, H.R. 5063 would inhibit those actions that are extremely important in the civil rights of all. And so this amendment, number 8, would have a direct impact on these very type of cases, the Jackson-Lee Amendment, by providing an exception to cases where funds are directed to the remediation or generalized harm, as highlighted in the above agreements, that falls within the category of other than direct restitution to identify our victims, as I indicated, cases like sexual harassment, violence, discrimination, and other civil rights actions. Let me just briefly make one comment as I close. Again, to the members of the committee, this is not squarely on the point of the legislation, but it does speak to what happens to victims who are suing in the landscape of newly constructed so-called tort reform. This is shooting survivors owe $700,000 to the theater. This is the tragic case dealing with the numbers of shootings by an individual at Aurora, Colorado, which many of us remember, one of the mass shootings that we experienced and our heart was broken. One of the victims had a profound loss. This victim was paralyzed, her child was killed, and the baby that she was carrying was killed. She was to share $140,000 with 41 people. She was so distraught that she said she would not accept that settlement, which meant that the $140,000 was not even paid to the other 41 victims. This is, of course, what many of us as lawyers who practice tort reform, which we know it's not the big guys, it's the little guys that count. I would ask my colleagues to consider these amendments because they deal with helping the little guys. I yield back.
Thank you very much. Excuse me just a moment, please. Thank you very much for your testimony. All three of you have brought interesting amendments. I will tell you, Ms. Jackson-Lee, I don't often try and take huge issues with people, but I would tell you as a strong advocate for those that are disabled in this country, we found a way through the law to make accommodations. I don't believe that the President, the Attorney General, or this administration, the Department of Education, the Office of Civil Rights, or the Department of Justice has done that as it relates to the locker room issue. And I believe they're dead wrong, and I would go strongly against any money that would be given these groups to empower a decision that was made by the Office of Civil Rights, the Office of the President, or the Attorney General to rule what I believe is a poor decision, instead of allowing accommodations to follow the law that they would choose to, and that they're putting off on many school districts in Texas. They're picking smaller districts that do not have the money, the resources to fight these lawsuits. I am so pleased with not only North Carolina but other states, and saw that a federal district judge received a temporary restraining order denying the president the ability to make these locker room changes that this president, activist, leftist president wants to do. And I would tell you that I would be deeply disappointed and offended if this administration chose to give money to people based upon that issue. I believe it's well outside the mainstream of this country, and I don't have any daughters, but I would be very upset if this administration prevailed in that decision with children who would be in schools. I believe it's unwise. I believe it's un-American, and I don't believe that it has anything to do with the civil rights. I think it has to do with politics, and I'm angry as I move throughout a district in Dallas, Texas, of Saxe, Texas, Wiley, Texas, Rowlett, Texas, where these school boards are having to deal with a federal government that I believe is dangerous and a federal government that I believe is outlandish in what they do. Thank you very much. Mrs. Fox? No, ma'am, I don't intend to engage. I told you I'm not trying to engage. It was just my opinion. Thank you very much. Mrs. Fox?
Thank you very much. I have no questions of our colleagues.
Thank you very
But I
much.
appreciate their coming.
Mr. McGovern?
I want to thank everybody for being here. I hope you get an opportunity to have your amendments made in order. Mr. Chairman, I strongly disagree with your opinion, but I don't want to engage.
Right.
We should move on, and
Right.
I hope we can do that.
Mr.
Yes, sir.
McGovern, might I yield just a comment,
I
please?
yield to the gentlelady for a quick comment.
I greatly appreciate it. It would be very quickly. My amendment rises on a number of examples, EEOC case dealing with female laundry workers, but I would only make the comment that my point is that any form of discrimination which may occur, this legislation, underlying legislation, would have a negative impact. I'll just say for the record, Attorney General Paxton, that is the State Attorney General of Texas, just a few days ago visited a family of a transgender child of about 6 or 7. The mother invited he and his wife to dinner to meet their child. I think we all have our opinions, and I have the humblest respect for those opinions. But my amendment rises on the idea of discrimination and what would happen in any lawsuit outside of the one that I cited in a settlement where some person would not be able to get full relief. I thank you for that.
Made in order. Thank you. I yield back.
Yes, sir, thank you very much. The gentleman from Florida. Gentleman does not seek time. Is there any other member of the committee that seeks time for questions? The gentleman from Louisville, Texas, Dr. Burgess.
Thank you, Mr. Chairman. I don't have a question. I just want to thank the chairman of the Budget Committee for bringing these amendments to the committee's attention, and I hope the committee will look favorably upon them and make them in order, and I will yield back.
Thank you very much. Any other member of the committee? Seeing none, I want to thank you all for being here, and I hope you all have a great evening. Thank you very much. Yes, ma'am. The committee will recognize that we're about 2 minutes away from receiving our paperwork now that we have completed the exercise of testimony. And I want to thank members for coming today for this important hearing. And so we will stand by here very quickly. I'm told it's rolling off the printer as we speak. Chair will now be in receipt of a motion from the gentlewoman from Grandfather Community, North Carolina.
Mr. Chairman, I move the committee grant H.R. 2357, the Accelerating Access to Capital Act of 2015, a structured rule. The rule provides 1 hour general debate equally divided and controlled by the chair and ranking minority member. Committee on Financial Services, the rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-62 and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order only those further amendments printed in Part A of the Rules Committee report. Each such amendment may be offered only in the order printed in the report may be offered only by a member designated in the report and shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to demand for division of the question. The rule waives all points of order against the amendments printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 5424, the Investment Advisors Modernization Act of 2016. Under a structured rule, the rule provides 1 hour debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Financial Services, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes an order only the further amendment printed in Part B of the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part B of the report. Finally, the rule provides one motion to recommit with or without instructions.
You've now heard the motion from the gentleman from North Carolina. Committee is now open for discussion or amendment to that. Gentleman from Massachusetts.
Chairman, I have an amendment to the rule. I move the committee grant H.R. 2357 and H.R. 5424 each an open rule so that all members may have an
That's what
opportunity to offer amendments to the bills on the floor.
Thank you very much. Discussion.
67.
Those in favor of the McGovern amendment signify by saying aye.
Aye.
Those opposed, no.
Sounds like the ayes have it.
Noes have it, noes have it. And
You can what?
the motion is not, the amendment is not agreed to. Further amendment or discussion? Okay, the vote will now be on the motion from the gentleman from North Carolina. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
The ayes have it, the ayes
Ask
have
for
it.
roll call on that.
Gentleman asks for a roll call vote.
Ms. Fox?
Aye.
Ms. Fox, aye. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Mr. Newhouse, aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings? Mr. Hastings, no. Mr. Polis? Mr. Chairman?
Aye.
Mr. Chairman,
report the
aye.
total.
9 yeas, 2 nays.
The motion is agreed to, and the gentleman, I will be handling this for Republicans,
Mr. Polis will handle it for the
and
Democrats.
Mr. Polis for Democrats. Thank you very much. The gentlewoman now is going to approach the committee with a motion.
Mr. Chairman, I move the committee grant H.R. 5063, the Stop Settlement Slush Funds Act of 2016, a structured rule. The rule waives all points of order against consideration of the bill. Rule provides 1 hour general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary. The rule makes an order as original text for the purpose of amendment. The amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, and provides it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
You now have the motion for the gentlewoman from North Carolina. Amendment or discussion?
Yes, Mr. Chairman.
Gentleman's recognized.
Mr. Chairman, I have an amendment to the rule, and I move the committee grant H.R. 5063 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
I thank the gentleman. Discussion? Hearing none, the vote will now be on the amendment from the gentleman from Florida. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
Noes have it, noes have it. Any further amendment The vote will now be on the motion from the gentlewoman from Grandfather Community, North Carolina. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
Ayes have it, ayes have it.
Roll call, Mr. Chairman?
Gentleman asks for a roll call vote.
Ms. Fox?
Aye.
Ms. Fox, aye. Mr. Cole?
Yes.
Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Mr. Newhouse, aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings?
No.
Mr. Hastings, no. Mr. Polis? Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
9 yeas, 2
The
nays.
motion is agreed to, and the gentleman from Georgia, Mr. Collins, will be handling this for Republicans.
And I will handle it for the
And the gentleman, Mr. McGovern, for Democrats will be handling this. At this moment, we do not have another meeting scheduled for this week, but I would anticipate that today is Tuesday and tomorrow's Wednesday, so we'll see what the week yields. But at this point, there is nothing scheduled. Once again, knowing today is not a Monday, today is a Tuesday, and we'll move forward. I want to thank the committee for their attention and work, and welcome our awesome stenographers here this evening. This finishes our work for the day.